You've got to go out, if in a dispute you're going to audit, and I'm using a dispute context, if you're going to have to audit, and you can't get past what you're going to audit and how you're going to audit it, it's sort of like a game stopper before you start.
One thing was the onerous conditions put on the auditors, things like confidentiality agreements, requirements to produce a report afterwards, requirement to meet with people afterwards. Meanwhile, on the other side, they don't give you access to their personnel, those sort of things. I was actually involved in a dispute. Ultimately, everybody kind of agreed on something somewhat more reasonable. But one question I was going to ask you guys is what you thought was a reasonable condition, if any, to put on an audit.
Well, John, you want to go first?
Well, I've been asked to sign some confidentiality agreements that have some pretty egregious terms. It really is problematic. I have no problem signing confidentiality agreements, and we kind of have created an acceptable template that we try to send out where we're in that situation to our client to head off some of those disputes. Doesn't always work, but having something prepared that you send out and are in control of, I think, is helpful.
Yeah, and then to follow that up, not just in, signing confidentiality, it goes beyond that, because I think your question actually goes beyond and says, now they're going to give access to records. But what records are you going to get access to do the audit, which entails a confidentiality question, but then it gets into the issue itself of the scope of the audit.
Right.
And there's what kind of audit am I willing to conduct? And that's the problem with the access to records clauses in general. You can only put so much in there and have to rely on faith between the parties and maybe what's done standardly. But all that goes out the window in a dispute. So that's a great lead into a lesson learned. Wendy and I, my partner, were called several years ago in what I'll call was a very contentious dispute with significant balances at stake. And we're talking in the, let's say north of, it was hundreds and hundreds of millions. And there were several reinsurers involved that were under a joint process. We came in much later in the process because the audit totally stalled. There was a third-party auditor inside doing the audit who's very qualified, has the qualifications to do it, so didn't have the situation you were confronted with. And as they got into the procedures they wanted to conduct, they actually set up a procedure where each audit procedure they wanted to do, including what they would do in the scope of it, was subject to I call it a document. It was all documented. They were numbered procedures. Well, as the process got along, the parties started to argue about everything to do with it, the procedures and the size of the samples. The arbitration panel, which was some of the seasoned arbitrators in the profession, was running into scheduling problems. That's a common thing. We hear that quite a bit, the ones who are in scheduling problems. And what ultimately happened is, because the arbitration had been postponed once, they set a line in his hand and they said, it's not going to be postponed again, so you will get this audit done. Since the parties were fighting, they went outside and looked for somebody to mediate. I'll use the word mediate, but when we were called, somebody said, would you like to serve as a special audit master? And the first reaction we had was, if you tell us what it is, we'll be happy to do it. But I had never heard, I only heard of special audit master in connection with court litigations. I had never heard it used in connection with an arbitration proceeding before. So I thought it was something like that. So what happened ultimately was the panel delegated the responsibility to get the audit done to us, and therefore rule on each one of these, and I say not one, there were many, many audit procedures, to be able to get it conducted in a timely and efficient fashion and get it back on track. It was, we took this task on with a lot of trepidation, as we will say, because besides 4 major reinsurers being involved, there were 4 major law firms being involved, and the attitude, the only thing I could think of was, we can't win. We're actually going to aggravate every single person. We can't possibly satisfy them all. But they were so aggravated already that we had an upside. The upside was we would get it back on track, and we did. We were very fortunate to get it back on track, issued the rulings, and I found out, which is interesting, my retirement job, I want to be either a special audit master or an umpire, because I find that it's a lot better to be the one that gets to listen to everybody and tell them what to do, or judge, if I was a lawyer, a judge. Because doing that became a rewarding experience. Anyhow, the long and short of it was we were able to get the parties to agree. Most of the time, we got the parties to agree without us telling them what to do. We just said, what do you both think? And they tended to agree, and they said, are you okay with that? They got it done. They got it back on track. And in this particular case, the last party settled the night before the arbitration proceeding, so it was settled out. This was, by the way, for those who are ARIAS members and follow it, this was a subject of a very lengthy article, no names involved, in the ARIAS Quarterly about a year and a half ago, which said there are circumstances where the use of an outside party might actually would be beneficial. What we thought was kind of interesting about it is there are certainly arbitrators that felt, in hearing about that was inappropriate. In other words, that was a panel delegating their authority, and therefore that's inappropriate. It was not, the right thing to do, and there'll be people on both sides of that argument. I'm sure everybody has their own opinion of it, but at the end of the day, it seemed to be a reasonable outcome for the parties that were involved.